Good day, viewers. This is another law lesson from the Law Basket with me, Santiri S. Bangura. On the 1st of January 2021, the President, His Excellency, retired Brigadier Julius Maada put into exhibition one of his constitutional functions by granting presidential pardon to prisoners right across the country. Ever since that day, there has been huge controversies surrounding the legal effect of the prerogative of mercy. So in this lesson, kindly permit me to take you through the legal effect of the prerogative of mercy. But before that, I am going to put forward, firstly, its constitutional establishment, secondly, its nature at common law, and lastly, its legal effect. To start with the legal basis for the establishment of the prerogative of mercy, it is serious to note that the establishment of the prerogative of mercy is enacted in the 1991 Constitution of Sierra Leone pursuant to Section 63, subsection 1 of the just stated Constitution. And that very section reads, the President may, acting in accordance with the advice of a committee appointed by the Cabinet over which the Vice President shall preside, A. Grant any person convicted of any offense against the laws of Sierra Leone a pardon, either free or subject to lawful conditions. B. Grant to any person a respite, either indefinite or for a specified period, of the execution of any punishment imposed on that person for such an offense. C. Substitute a less severe form of punishment for any punishment imposed on any person for such an offense. And D. Remit the whole or any part of any punishment imposed upon any person for such an offense or any penalty or forfeiture otherwise due to the government on account of such an offense. However, Section 63, subsection 2 of the same puts forward a prerequisite to be fulfilled, as this section states that where any person has been sentenced to death by any court for any offense, the committee appointed under subsection 1 shall cause a written report of the case from the trial judge, together with such other information, including a medical report on the prisoner, derived from the record of the case or elsewhere, as the committee may require, to be submitted to it as soon as possible. At this point, conversely, it is best for us to glance sparingly at the nature of the prerogative of mercy at common law. It was well settled that a pardon by the king removed not only the punishment that flowed from the offense, but also all legal disabilities consequent on the crime, as was held in the case of Condington against Wilkins, 1614. At this juncture, let's see if the common law provision is in total conformity with the 1991 Constitution by moving directly to the legal effect of the prerogative of mercy. In consequence to the earlier mentioned constitutional provision, it is clear that presidential pardon does not mean exoneration, just as in the case at common law. So, the case at common law. So, this means a presidential pardon may restore various rights lost as a result of the pardon offense, and also may mitigate to some extent the stigma arising or punishment from a conviction, but does not erase or expunge the record of the conviction itself. In actual sense, a presidential pardon relieves the offender of all punishment, penalties, and disabilities that flow directly from the conviction. So therefore, it can be inferred that a prerogative of mercy expresses a total forgiveness and not necessarily innocence, for one can still be pardoned and yet the criminal conviction remains intact. Thank you for your kind attention, and please do not forget to like and subscribe to this channel.